Everybody liked it. It was easy to do. Everybody else did it. NHTSA liked it. NHTSA just had little fixes, little beveling around the edges, little slight improvements, but it was just the best thing ever, the bullet, and that's what he argued, and that would not have gotten him the instruction that I ended up giving. But then he went right ahead and said, and I don't know why Ride the Duck Seattle didn't do it, strongly implying they had a duty to adopt the bulletin and to implement the bulletin, which they may not have. It's my job to instruct on duty, and the language on duty is the language I then gave the jury. It was directly responsive to Ride the Ducks International's puzzlement about why this wonderful bulletin wasn't implemented. Later, in Ride the Ducks Seattle's closing, when Ride the Ducks Seattle dealt with the instruction, I reminded the jury again, this was about the argument, if there is an argument, that the bulletin was an approved appliance. So I read the plaintiff's recent briefing that I just got on this thinking, first of all, it's late, okay? This concern, if you have one, should have been raised on Wednesday when this was all discussed. This is not new. I indicated I would give the instruction Ride the Ducks Seattle proposed in closing argument if Ride the Ducks International went there, which they did. And I made it clear both times I said this, first in terms of when I said it, and then again when I said this was about this possible argument about the bulletin, that it was responsive to RTDI's argument. Now, having said that, I'm in agreement with plaintiffs that your recitation of law in your brief, that as a common carrier, RTDS had the duty to protect its passengers from the danger of injury from malfunctions or defects of which they knew or should have anticipated from the circumstances known to them, is an accurate statement of law. And it is, in fact, the statement of law on which Mr. Puz is implicitly relying currently in making his argument that the failure to do anything when you're told your axle might fracture was a violation of common carrier and ordinary carrier duty. So I'm not going to preclude the plaintiff from making this law-based argument to the jury in your rebuttal, and I'm telling you that now. Okay, I'm not going to instruct on it. Obviously, RTDS's closing has happened. I've said what I need to say about what the law is that applies to RTDI's argument, and I'm not going further than I've already gone. And I already signaled I would go on Wednesday before any of these arguments were given. All right, end of story. Let's bring in our jury. No, bring in our jury. I'll hear from you when the jury's out, Mr. King.
Thank you.
Be seated, everybody. Welcome back, ladies and gentlemen. All right, please give your attention again to Mr. Puz, if you would.
Fill everybody up with lunch and then sit them in front of an attorney who's going to talk for another 45 minutes. Oh my gosh, that's like the dream come true, isn't it? All right. We were talking about Ride the Ducks Seattle. We were talking about all of the things that they did to breach, whether it's common carrier duty or ordinary care. The evidence is profound and overwhelming. And I want to turn, if we could, Mr. Allen. This you're starting to recognize is the verdict form. And these first questions pertain to Ride the Ducks Seattle, and Ms. Buchanan went over these questions. Once again, you will be asked whether or not there's a breach and whether or not that breach was a proximate cause of the injuries to the plaintiffs in this case. We just got through talking about that, and the answer is yes to both of those. Next slide, please. The next one has to, so that first question had to do with the duct passengers. This is every other plaintiff other than the duct passengers. And so the question again is whether or not there was a breach and whether or not that breach was a proximate cause of the damages to the plaintiffs. And the answer is yes to both of those as well. So I just wanted to run through that instruction with you just so that you were seeing it again in light of the discussion that we had the opportunity to have before lunch. You know, let me wrap up on these ducts. It comes down to those two words that I told you were critically important up front. Engineering judgment. Had they sought engineering judgment 2003, 2004, any step along the way, followed what that judgment said, this accident, this crash would never have happened. They didn't, and as a result, the axle defect that they knew about spread, expanded, and caused the complete fracture of in the fracture zone. Fracture zone, we've heard that word a number of times. In the fracture zone of the front left axle of duct 6. And that, according to every single expert who's testified, was the cause of the mechanical failure that caused this crash. Okay. Now, in direct contrast to the lack of engineering judgment that plagued really every one of the steps along the way for the Ride the Ducks International and Ride the Ducks Seattle, every decision made about the Aurora Bridge was based on engineering judgment. It was based on principles and standards that are followed not just in Washington, but around the country. They're using the data-driven analysis that is the same one that's used by every transportation agency in the country, state, local, transportation agency used in the country. I want to step back before I dive into that one with both my feet. I don't know when it became a thing. I really don't. I don't know when it became a thing to blame the road for every unbelievably reckless action of a vehicle operator and vehicle manufacturer that happens. I mean, I just don't. I mean, you know, honestly, I think when faced with this kind of horrific crash, and this was a horrific crash, people look for ways to cope. They look for ways to understand. They look for ways to put it into perspective. And I think the more tragic and horrible the crash, the more people look for something pacifying, something tangible, something fixed to try and blame for what happened. you know, yeah, I've said it a million times, there was nothing about the road that caused this mechanical failure or crash. And yet, there's this sense, this feeling, if you would, of wanting to believe that the transportation agencies, they should have moved heaven and earth and done whatever was possible to prevent this crash. And that's kind of what the plaintiffs are doing here, right? I mean, we saw their closing and throw up a bunch of pictures of the horrible accident. I promise you, you're going to see a copy of the video of the crash played in rebuttal. I think it's being saved for that. You throw up a lot of pictures of the crash. You point to the roadway. You suggest that a barrier could have stopped this crash. And you blame the transportation agencies. Hey, who are these people, these transportation agencies? They're us. They live, they work in this area. They're dedicated, trained, committed people who are trying their level best to make sure that every one of the lane miles that are under their jurisdiction are reasonably safe for ordinary travel. They drive the bridge. Their friends drive the bridge. Their families drive the bridge. So what happens? We show some pictures, we make these claims, and they immediately start driving a 50-foot long, 14.5-foot zipper barrier machine right up onto the bridge, right? That's exactly what happened. And they hold it out like it's the answer to everything. No, we don't need to look at it. We don't need to figure it out. We don't need to figure out whether it makes sense here. We're just going to say it. Well, what happened? What happened when we tried to dig down into that? Gosh, do you know whether a movable barrier, how well it might, or what difficulties or problems might exist trying to match up a movable barrier with an anchored barrier on either side? Oh, no, we don't know about that. Well, here's an easy one. The lanes that you're moving from 3 to 2, how much congestion and problems is that going to cause? Oh, we don't know that. Well, okay. So you're going to move 3 lanes into 2. How far back on the approach to the bridge do you actually have to start planning and merging the traffic into? Well, we don't know that. Well, okay. How many additional crashes is the presence of a barrier on this bridge gonna cause? Oh, we don't know that. How are you gonna make the yellow lines that mark the shy distance on either side of the barrier magically move? Like Dr. Pfeiffer shared with us. No, we don't know. Shy distance. We've heard about that one in this. Shy distance is the area on either side of the median barrier that does a couple of things, actually. One, it provides a visual cue, right? So that we don't run into the barrier when we're driving on it. And the other thing it does is it provides a recovery area. It provides a recovery area so that if somebody does happen to get too close to the median, they're not going to hit the barrier. So Ms. Kohler throws up a slide that shows the yellow line painted on the barrier, which means no shy distance, right? It means no shy distance. So it's not only increasing the risk of crashes with the barrier, but this is a barrier that gets deflected when hit. So when it's moved by a collision, when it's moved by a collision, it's going to deflect where? It's going to deflect in the opposing lanes of traffic. Now, they wanted to pretend like, well, the road's just going to move over, they'll just glance off it. But that's not the way this works. This isn't a solid piece of cement. It's individual segments of cement. And when you move a segment over, only that segment comes out. So the collisions are almost a head-on collision for the opposing lanes of traffic. That's why you do shy distance, is you try and protect against those things. Shy distance. All right, let me give you an easy one with your zipper barrier proposal. How are you going to get it on the bridge, and where are you going to store it? One would think that would be maybe the most basic question, and certainly one that they should be able to answer if this is a real fix. We don't know the answer to that one. Dr. Pfeiffer testified twice, and the second time was specifically to address that issue, and he had no answer. You know what? This is the things that reasonable transportation agencies exercising ordinary care have to look at. And what you heard was the testimony of Mark Vandy and Don Chain, who both said, well, wait a minute, there is problems with hooking this up. And by the way, moving 3 lanes to 2 is going to cause congestion, and it's going to cause additional accidents. And even if you got past those problems that they're just unwilling to the details that they're unwilling to look at, what remains is the fact that placement of a barrier on a bridge is going to significantly increase the number of crashes. You know what? I can't explain how drivers drive. I mean, we're all drivers. I can't explain the actions that they do, but what is true is that they run into the barriers, and when you put a barrier on a roadway, it increases the number of crashes. So before looking at that, before doing that, you have to figure out whether the problem you're trying to shield from is greater or less than the problem that you're creating. All right, we're going to get into that in a minute. But I wanted to share with you that highway engineers don't chase random events. Most accidents are, huh? Most accidents are random events. They don't chase them for 2 reasons. One, it's just on the most basic level. It's a bad investment. You're taking away, you're putting money into something, chasing a random accident, and taking that money away from another project that's more deserving. But beyond that, there's consequences to the things that are done. There's consequences to introducing another roadside hazard onto a road. And you just simply don't do that when it's going to make the roadway unsafe. So. This is a good time. This is a great time. This is a fantastic time to talk about the instructions that have to do with the state's duty and the plaintiff's burden of proof in this case. Instruction 19, your packets. The city and state have a duty to exercise ordinary care in the design, construction, maintenance, and repair of public roads and highways to keep them in a reasonably safe condition for ordinary travel. Ordinary care, it's instruction 15, means the care a reasonably careful person would exercise under the same or similar circumstances. I don't need to tell you, public roadways are managed by public transportation agencies. And when we're talking about ordinary care of the people responsible for them, we're talking about how the ordinary care that's performed by transportation agencies. And transportation agencies, you've heard every single highway engineer tell you, is based on standards. It's based on the accumulation, the roll-up of the research that places like the Texas Transportation Institute, where Mr. Bullard works, and the real life experience of every transportation agency in the country are rolled up. So it's a best practices. It reflects the best thinking on the matter from highway engineers across the country. That's what ordinary care is in this regard. With respect to the plaintiff's burden of proof, instruction 14 directs that the plaintiffs have the burden of proving every element of their negligence claim against the city and state. I keep saying city and state. I don't represent the city. But when it comes to this roadway that we're talking about, the city and state have a shared responsibility. And so the duty falls to both of us. And so that's why I'm referring to both of us here. All right, plaintiffs have the burden of proof. The last paragraph of instruction 14 says that the plaintiffs fail to prove any of the propositions of their negligence claim, which includes proximate cause, then your verdict should be for the city and state. So let's walk through what the claims are. Well, there's been a couple of things about the bridge, right? There's been discussions about operating speed and lane width, and really the thrust, though, is the plaintiff's claim that there should have been a median barrier on the bridge. That was necessary to make it reasonably safe. That's their burden of proof in this case. And so let's talk about barriers, a little bit more detail. First, no one, and I'm gonna step back from that. There are roadways with opposing lanes of travel without center median barriers all around this city, all around this county, all around this state, all around this country. To listen to the plaintiffs, they would have you believe that every one of those roads is unsafe because it doesn't have a median barrier. And that's just simply not the case. You know that from driving on them, huh? But aside from that, we know that from an engineering point of view. Why? Because if you put a median barrier on a roadway that imprudently, you will increase the crashes that occur to a higher, more significant level than the type of collision you're trying to shield from. And when you do that, you make the roadway unsafe. I mean, it really is as simple as that. And so every decision that highway engineers do with respect to every lane mile that they're responsible for has an analysis, a data-driven analysis that looks at exactly that equation. Collision severity. Let's just talk about that for a second, huh? Are crossover collisions horrible? Yep. Knew that before you came to this case, right? They are bad. I mean, certainly we saw some, yet 7 of the 21 that happened on the Aurora Bridge in the 13.75 years before this crash. 7 of them were mirror clips. I suppose they aren't as severe, but most of them are. Absolutely. But the idea that running into a barrier is like a fender bender? Oh my gosh, are you kidding me? That's just plain wrong. They're violent collisions. They're violent collisions not only for the people who are in the cars that hit the cement wall, they're violent for the people who are struck by that car when it's redirected back into traffic. How do we know? We were shown a study by Mr. Bullard that went uncontroverted. Can we see the next slide, please? You remember this one. This was the study that nobody, and I mean nobody, disputed. And what it shows is 52% of hit barrier accidents produce fatal and other injuries. See, that's the third bullet there. In that study, 5.8% of the fatal accidents were crossover accidents. 8.7% of the fatalities came from hitting a vehicle barrier. These aren't fender benders, people. Call the question. How much do barriers increase the crash rate? 10 to 20% with barrier installation on freeways. All accidents can increase 50% or more on non-freeways, like this corridor, like this bridge. That's why they look at the roads carefully, the accident collision history carefully. Because you have to be able to distinguish whether it's a one-off, a random collision, or whether there's a pattern that shows that there's actually something wrong about the bridge that's leading to these. Right? You've heard about Caltrans in this case. Everybody remember that? Everybody remembers about the Caltrans. Let me say this about that. Caltrans study, well, let me say it like this. It's not ordinary care to demand of these transportation agencies that they follow a warrant requirement required by one state. Let's take that the positive way. It is ordinary care, and it was in this case for the state and city to follow the guidelines and rules and engineering judgment established by AASHTO that reflects the research of all states in this country. You know what? Even if you were just wrapped into the Caltrans study, it has a misperception what Mr. Stevens tried to do. The Caltrans study, even when you met that warrant, which by the way, it was designed for freeways, not for this kind of road. But even if you met it, it didn't require placement of a medium barrier on the road. It only called for an additional study. What is the additional study? Every single one of the highway engineers who testified in this case told you what the factors are for that study. Their collision history and traffic volume. Collision history and traffic volume. This isn't something It's a newfangled thing only in Washington. This is how every single state in the nation, every transportation agency in the nation, these are the factors they look at. Dr. Pfeiffer said in response to a question just 2 days ago, reasonable transportation agencies exercising ordinary care look at collision history and traffic volume to determine whether a center median barrier should be placed in a road. 2 days ago. And by the way, that mirrors what every other highway engineer has testified to in this case, because it is how every highway engineer exercising ordinary care acts. Those are the principles, those are the engineering principles, the engineering judgment that they follow. So, let's get to brass tacks. Let's dig into what the data actually does show, huh? Now, you heard that there are smaller studies where they'll look at 3 years, maybe 5 years. More comprehensive studies, they look at longer periods of time. And the journey I want to go on with you today is looking at a more comprehensive study. So let's take a look at this slide for a moment, shall we? Now, in this case, what you've heard is a lot of different ADTs. Well, we're covering a lot of time, a lot of different time, and what we've heard is that throughout that 13.75 year period between January 1st, 2002 and September 23rd, 2015, 13.75 years, there's been some variance in the ADT, and I captured every single one of them on this chart. Now, 84,700, that's what Mr. Stevens came up with. Remember that? I had him come up to the whiteboard and we used his 84,700 number and we figured out exactly how many cars that was over the course of a year, more than 30 million, and how long and how many cars that was over the course of the study that, or the time period that he looked at. The second line is how many vehicles traveled over the Aurora Bridge using those ADT numbers in that 13.75 years, huh? I mean, 84,700, that's 425 million cars that traveled over the Aurora Bridge during that period of time. But even if you went back and you used the lowest number that you heard for ADT, average daily traffic, 70,000, that's 351 million cars, 351,312,500 vehicles that passed over the Aurora Bridge during that period of time. The next line, there's no variance on that. This is undisputed. During that 13.75 years, there was a total number of crossover collisions, 21. And of those, 7 were the mirror clips, yeah. 0 fatalities and 1 serious injury. That, ladies and gentlemen, is the risk, the possibility, if you would, that you have to look at when determining whether or not to install a median barrier. And what does that actually show? Far less than 1%, exponentially less than 1% possibility of there even being any type of crossover collision on the Aurora Bridge. Well, why is this important? Because this is part of the math, right? This is part of the data. This is one side of the equation that you have to look at. So on one side of the equation, 0.00005977% chance of a crossover collision versus the studies that show the crash rate is going to go up by 50. All accidents are going to go up by more than 50%. And some of those, by the way, some of those are going to be fatalities and serious too. that's why. I mean, you heard every city and state engineer come and testify. They said the collision history doesn't justify this. It doesn't justify a center median barrier. This is what we're talking about. This is a 13-year period, more than a 13-year period before this crash. What Lance Bullard testified to is if you put a center median barrier on with this low % chance of a crossover collision, you're making the road less safe. How can it possibly be ordinary care to make the roadway less safe? I mean, it just doesn't make any sense. All right. I feel like I want to say, do you have any questions? Because I want to bring this one home because it's important. This is engineering judgment. This is what it looks like when we're talking about highways. These are the critical factors that we all expect, we have to expect our engineers, highway engineers, to follow. So, proximate cause. All right, let's talk proximate cause. Proximate cause, as you've heard a little bit earlier, is, and it's instruction 16, and it's an important one. You're going to use it for all of these. You should use it for all of them because it's critical. Proximate cause is, quote, a cause which in a direct sequence produces the injury and or event complained of, and without which such injury and or event would not have happened, close quote. Yeah, what? That's them. That's the ducks. They had the axle defect that they didn't fix. They didn't get any engineering input into it, and there's a direct sequence between that and the very type of catastrophic crash that they knew could happen with that. Well, let's look at it in the terms that we're talking now, in terms of the highway. We talked about the median barrier. Now, we talked about the median barrier and why it doesn't make any sense. Proximate cause. I mean, we're not talking about a vehicle. We're not talking about a bus. We're not talking about a box truck. We're talking about a 13-ton military vehicle that has a bow. Yeah, a bow. The bow, steel angled bow of this duck boat itself, the spear of that stood about 6 feet off the ground. What's that for? It's to help it lift up and over. Huh? We saw that crash. It did lift up when it hit the bus. People, transportation agencies, they don't do test crashes with duck boats. My gosh, what you've learned in this trial is the duck boats are like, what, 4 states? And even there, they're limited, huh? In terms of number? How a duck boat might interact with a barrier, oh my gosh, it's anybody's guess. There are no test crashes or crash tests done with them, and whether it would have gone up and over or how it would have reacted, really, you heard Mr. Bullard, he does this for a living. That's what he does. He does crash tests on vehicles. He said there's no way to know without running a crash test. And there's no way the plaintiffs can prove, and they haven't here, how the duck boat would have reacted with a barrier even if it was there, huh? So not only does it not make sense, but they haven't made the proximate cause element. What's the other 2 things that they came up with? Speed, the operating speed, and lane width. We talked about that one before. There is no evidence that these vehicles were speeding, the bus or the duck, at the time of this crash. Speed had nothing to do with this crash. So whatever you think about the operating speed of the vehicles that drive across the Aurora Bridge, they were not in any way the proximate cause of this crash. Well, what about the lane width? Same thing. I mean, we walked through this before. Eric Bishop, he got on the bridge. The first thing he does is do what? I mean, he moved over a lane. He moved over and occupied 2 lanes. He had 19 feet of lane width as he was crossing the bridge. That's more than 1.5 times the greatest standard of width required on any roadway. More than 1.5 times. Hey, there's nothing about lane width that had anything to do with this crash, because there was no way the lane, regardless of its width, was going to control this duck boat that had no steering and had no brakes and it was driverless. Lane width had nothing to do with this crash, and it was absolutely not a proximate cause of why this crash happened. Now, I guess the government's an easy mark. They do reports, they criticize, they do reports, they're criticized, they don't do reports, they're criticized. Let's talk about what they did. Let's talk about what they did. Was the city and state aware that having opposing lanes of traffic adjacent to one another posed a chance of a crossover collision? You don't need a study for that. Yeah, I mean, you know that to be true. But they did study it. They looked at this time and time and time again. They looked at it from every possible angle. 2003, they completed the route development plan. The 2003 route development plan was a 2-year study that looked at every aspect of that entire corridor, right? They sought public input. They took emails, they made phone calls, they met with businesses, they met with the public, they met with transit, they met with the city of Shoreline, with the city of Seattle involved, the state of Washington was involved. This was a comprehensive study. What kind of study and what was its purpose? It was a 25-year planning document. Because it turns out that when you're looking to budget and seek money from the legislature for that budget and for improvements going forward, you gotta plan for it, huh? You gotta plan for it. And so it's a 25-year document, a 25-year planning document that's designed to evaluate the operation of the road from every angle, huh? They looked at geometry of the road, they looked at pedestrian accidents, they looked at traffic volume, they looked at collision history, they looked at absolutely every aspect of this. And as part of it, one of the things they did is they said, okay, this is a planning document, let's have some ideas for things that we may fix if some of the problems, if some of the potential problems come to fruition. And they did. They came up with the cantilever sidewalk idea. Not engineered, wasn't designed, it was supposed to be engineered. This was a planning document. But it was an idea and the beginnings of an idea of what the city and state would look at and consider if the trigger was ever met. What trigger? It's the trigger we just got through talking about. It's the two factors that control whether or not a center median barrier goes on any roadway. Collision history, traffic volume. They looked at it again in a study in 2008 and 2009. And not only that, they studied the traffic history every single year. The city, every week, they're looking at this. Weekly and annually. Because they want to know if and when that calculus changes, they're prepared to act. But it never did. Not once. Those probabilities I showed you remain for that entire 13.75 years. Okay. All right.
How much longer does Mr. Post?
I'm going to be about 15 minutes more.
All right. I'm going to hold you to that, Mr. Post.
Okay.
Seriously.
I believe you.
Go ahead.
All right. Talk instructions. Instruction number 6. Don't know if I have that one. This is the instruction that 5 is the one that deals with the state. And the question put before you is whether or not the state was negligent. Did the plaintiffs meet their burden of proof of showing that a center median barrier was required to make this bridge reasonably safe for ordinary travel? Or was it reasonably safe for ordinary travel in its present form? I just walked you through the entire analysis, the entire engineering judgment that goes into this. Outlined all of the studies and information that was used and considered in that. The answer to that question counsel stood up and said she let her co-counsel win one by coming up with an arbitrary base participation number. Are you kidding me? Are you kidding me? And she followed that up by saying, you'll be responsible for their injuries if you don't give them what they want. No. 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 No, that's not only outrageous and offensive, it's just disrespectful. It's disrespectful of the time commitment you put into this case to date. And by the way, it's contrary to the law. Where's the law? Glad you asked. Instructions. Instruction 31 through 47 address the damages that you can consider for each plaintiff. Every single one of those instructions state the plaintiffs have the burden of proving the damages that will fairly and reasonably compensate the plaintiffs for the damages they suffer. That each damage element must be proved by a preponderance of the evidence, quote, based on the evidence. And to the extent any doubt remained, all 17 of those damage instructions state, quote, your award must be based on evidence and not speculation, guess, or conjecture, close quote. The idea that every plaintiff, the idea that you award every plaintiff a base participation fee in this is contrary to the law. It's contrary to each of those instructions. You know what? Let me climb down off my soapbox for a second. Let's talk about a couple of the cases and a couple of the ways that you can analyze the particular plaintiffs in determining damages. Now, you've heard numbers given by everyone before me, and I'm not going to spend a lot of time doing that. Where I am going to focus my time is one of the plaintiffs that some of the others didn't address. And I guess I want to get into it, I guess for two reasons. One is I want to share with you the analysis that the instructions direct. And two, I want to share with you how you have to look at this particular kind of case, because it is a little bit different. It has to do with Harem Kim. Now, Harem Kim was on the bus and she was killed. Yeah? And so what we look at in her case is determining the net accumulations. This isn't a case where you can award non-pecuniary damages. They're not available to her. That's not something the plaintiffs can ask you for, and it's not something you can award. So what we have to do is we have to figure out, actually it's two things. One, we have to figure out the healthcare expenses to date, yeah, because she is entitled to recover that. Assuming you find liability against at least some of the defendants, and I would suggest to you, yep, you should do that. And the second piece is the net accumulations to the estate, okay? So let's walk through that analysis. It's gonna have a few slides, but I'm only gonna do this for one plaintiff, okay? That's my fair warning. All right, let's get the first one. Jury instruction 47 is the one that deals with Ms. Harem Kim. Once again, as we just talked about, the burden of proof is on the estate of Ms. Kim to prove the amount of money that will reasonably and fairly compensate the estate for the damages approximately caused by the negligence fault of one or more defendant. It must be based on evidence, not speculation. If you find for the plaintiff, your verdict must include the undisputed health care expenses, $273,389.72. Those are undisputed. Plaintiffs and defendants agree to that. So that's going to be part of whatever award that you make to Ms. Kim. In addition, you have to consider the net accumulations to the estate. Next slide. Net accumulations is described as the earnings that Ms. Kim reasonably would have been expected to earn in the future, including any pension benefits, minus the amount that she reasonably would have consumed as personal expenses over her expected life. We heard a number of economists talk about this, and I'm not going to spend any more time on that, but that's basically the formula. It's the amount of earnings less the amount of consumption. Net accumulations must also be expressed in present cash value. We also heard a lot of testimony didn't we? Present cash value is the sum of money needed now, and this, I'm sorry, is instruction 52. Present cash value is the sum of money needed now, which if invested at a reasonable rate of return would equal her net accumulations at the end of her expected life. Okay, next slide. These are the factors that the instruction suggested you consider: her age, which was 20 years, her health, which was excellent, her life expectancy, that was the table that you were presented in the instructions, it's 80.58. Her occupation was a student, habits of industry, responsibility, and thrift. There really wasn't any evidence directly on that. And actual earnings prior to death, well, there wasn't really evidence on that either, which was in school. She wasn't really working. Next slide. Discount rate. Gosh, got a lot about that as well. You heard the opinion of two experts talk about this. The discount rate, which has to be taken into consideration in factoring this calculation. You heard Dr. Tapia. She used one-year U.S. Treasury bills. Mr. Parton, he offered two different approaches. One matched the maturity of investment with time, and then both Treasury bills and a blended portfolio of securities reflecting the long-term investment. Now, one of the reasons that Dr. Tapia used for the one-year Treasury bills was the idea that over the course of some of the injured lives, again, not the estates, but over the course of their lives, they would have a need to access that money at various points for whatever expenses they would need over the course of their life. That's not the calculation that we have here. The calculation that we're trying to do here is we're trying to figure out how much money is needed today that would reach the amount of net accumulations at the end of their life. Yeah? So one-year Treasury bills that provides the least amount and the lowest interest rate, it doesn't really follow here. Okay, next slide. So, Mr. Parton. Mr. Parton, well, step back for a second. How is this driven in terms of when somebody doesn't have an occupation, when somebody's a student like Ms. Kim was at her untimely death? What you look at is what level of education was she on a more probable than not basis likely to achieve over her life. And with that comes expected earnings, benefits, etc., from which you can make the net accumulation calculation. Now, there's three different categories that were testified to you today during this trial. One was, had she received an associate's degree, and the numbers are there, using both the blended portfolio and the tiered treasury. A bachelor's degree, same thing, and a medical degree. Mr. Parton gave information about the first and the second category and concluded that the evidence doesn't support on a more probable than not basis that a medical degree would be obtained by Ms. Kim. Dr. Tapia wouldn't think of anything and didn't think of anything and didn't offer any opinions on anything other than a medical degree. And these are the numbers that were provided to you in evidence. Next slide. Evidence relied upon for net accumulations. Again, this is the evidence that you use to try and figure out, well, how far was she going to go in school? She graduated high school. She was enrolled at North Seattle College. She was taking English classes. There were no advanced classes that she was taking there. There were certainly no classes that she was taking that were requirements or pre-requirements for med school. 36% of adults between ages 25 to 29 earn a bachelor's degree or higher. 9% of adults ages 25 to 29 earn a master's degree or higher. So this is the evidence that Mr. Parton used to say, medical degree, no, there's not evidence to calculate that number. Next slide. So what's the total damages range here? Well, you look at the low and you look at the high, yeah? I mean, that's pretty straightforward. So you have what's fixed is the healthcare costs. You have the lowest degree that she would have obtained, converted to present cash value. That was the AA degree, and we threw in here for males and females. And the number there is 340,000 total for everything. The high is the same healthcare costs. And Dr. Tapia's number, assuming medical degree. And that's the total there. That's your range. That's what the evidence is about. That's what it shows. Next slide. I'm going to suggest to you this. I'm going to suggest to you that Hiram Kim was a very talented young woman, but there just simply isn't evidence in the record to support that she was going to go to medical school. I think there is evidence in the record that she was going to get a BA. She's going to get a bachelor's degree. And that's what I'm suggesting would be the appropriate amount of damages for Ms. Kim in this case. So it would be this amount, plus this would be the figure that would go into the net accumulations. And this would be the total amount that would be paid to the estate. Okay? Okay, that's all I'm going to say about that. What about the non-death claim? Non-death claims. What's the best way to approach those, you might ask? And I am so very glad that you asked me that question, because I do have a suggestion for you to look at. Non-economic damages. Instructions 31 to 47 tell you should consider a number of elements in determining the amount of non-economic damages you award to the plaintiff. That's the law, right? The very first element is the nature and extent of the injuries. Now, that's one of the best markers to use, initial markers to use in determining non-economic damages, because it marks the costs that have been paid in medical expenses are a good representation of the amount of physical injuries that person suffered, yeah? So it has the added benefit of what? Being based on the evidence. We know what those numbers are. Next slide. Now you've heard some question about whether all of the damages have been accepted or disputed. It's an interesting thing in this case, because in this case, gosh, remember you heard testimony from Dr. Olson and Tony Chapa. God, how many times was Dr. Olson in front of you? Talking about expected future needs in terms of healthcare costs. It was factored into the life care plan, and we had charts out here, and people were filling things out. For most of the plaintiffs, they've waived those. They've waived those. The care that they claimed was necessary to lessen the emotional impact of this injury, they have waived them and are not seeking them. That's what this chart shows. First column, this is the reasonable value of past care according to Mr. Chapa. Mr. Chapa was the plaintiff's guy, right? It was the plaintiff's person who put these numbers up, who tallied these numbers for us. So you bought 11,055. This is a chart that doesn't get to go back to the jury room with you, but we put next to it the jury instruction that it corresponds with for those people, because this is the best indication of where we start for this. 11,055.60 for Ms. Bach. Mr. Klaus, 9,354.86. Rhonda Cooley, $69,470.25. Long Din, $613,109.03. Lilu Edwards, $9,255.17. Jennifer Emery, $41,540.16. Joanne Gerke, $44,423.40. Susan Gessner, $42,737.87. Timothy Gessner, $11,188.69. Kenichiro Hiroka, $3,768.95. This amount for Sonoko Hiroka is undisputed by the parties, huh? Toshiko Hiroka, his medical costs were $9,300. Yusuke Hiroka, $2,190. Next slide. You'll note the death claims aren't on here, huh? Moritz and Felix Dershman, because it's a different analysis that we're using, and actually it's been covered already. Ms. Kim's isn't included in this. Claudia Dershman's estate isn't included in this. These are the rest of the folks. And what we're looking at here, when it says no, these are the people who have waived the costs that they claim are necessary as damages to relieve them of emotional stress they're seeking in non-economic damages. It doesn't even make sense to me.
Mr. Haas?
The way that I would suggest you use these in the non-death claims is you use this like the instruction says. You look at what the personal injuries are that they suffered. This is the cost, this is the proof, this is the evidence of what that was. And you use this as a starting point. And for people who are not as injured, people who walked off the bridge, who sought no treatment or limited treatment, sought a little bit of counseling and then decided to stop, what I would suggest you do is you match the amount of their costs in terms of their non-economic damages. For more serious people, strike that, for more seriously injured people, you use their cost as a base and you look at all of the other factors that are in the instructions and you adjust that sum, that matching sum, what, 2 times, 3 times, according to the evidence that you've been presented with. That is the added benefit of not only being based on the evidence, which, by the way, the jury instructions require, take into consideration the factors that are required for non-economic damages. It also provides something real for you to use in figuring out this calculation. I've explained several times in this trial why the Aurora Bridge was the place where this accident happened, where it wasn't the cause. This accident was caused by the breach, the multiple breaches of the duties that were owed by Ride the Ducks International and Ride the Ducks Seattle. And for all of the reasons that I just shared with you, and all of the instructions that we just went through, I'm asking you to hold them entirely responsible, 100% responsible for the crash they caused. We spent 3.5 months together, more than 3.5 months together. Just to echo something the judge said, when we first built this with jurors, I, like the judge, believed that serving on a jury is one of the most important and honorable civic duties we have. And I appreciate the time and the commitment and the attention you've spent to that in this case, and I'm confident that you will reach the right verdict after your deliberations. Thank you so much.
Thank you. All right, let's go ahead and stop. We'll see everybody in 15 minutes, and then we'll hear from the state and rebuttal from the plaintiff.
February 6 to 10.
Thanks. Be seated. Where's Mr. Cedar? Cedar, do you think you can keep it to 45 minutes?
Yes, Your Honor.
Maybe a little less?
That's my goal.
That would be good.
Mr. Puz covered a few of the things I was going to cover.
I would hope so. Mr. Putz went, well, almost triple his estimate. Certainly well over it. That's all right, Mr. Putz. They just don't want to hold the jury until 5:30, you know what I'm saying? We will get done today.
Your Honor, file a motion on the two requests for curative instructions I made earlier, understanding that I just want to make my record, but also that you've already addressed them and you've said no.
Which curative instruction? Yesterday's argument?
Yes, Your Honor.
No, I'm not going to revisit that again. If you file it, I'm going to give you a motion to reconsider and deny it.
Thank you, Your Honor.
Not that I don't love reading all your briefing posts, but there comes a time when I've ruled and we're done.
Thank you.
Admit it, Judge, we're going to miss this next week.
I am going to miss you. It's been so much fun watching you all in action. You're wonderful lawyers. Even when I say no to you, I feel that way.
Is that all the record?
No. That was good.
I have the jury.
Let's go.
Also, counsel watched me in certain numbers and
Oh, good to know. Let's go. See, Andrea's helped a little bit. Everybody, welcome back, ladies and gentlemen. All right, please give your attention to Mr. Cedar in closing argument for the City of Seattle.
Thank you, Your Honor. This is a case about a terrible, terrible accident caused by a broken axle. could you fire up the machinery, please? Thank you. May it please the court, counsel, ladies and gentlemen of the jury, most importantly, ladies and gentlemen of the jury, because you have the most important job. You need to do something that's really hard, which is eliminate hindsight bias. And an example comes to mind. Ms. Kohler yesterday said that the key point in time for the city and state was the 90s. Construction costs were low, and that's when changes could have been made to the bridge. In the early 90s, a guy named Kurt Cobain was sleeping in his car in Pioneer Square. And Eddie Vedder was an unsuccessful singer in San Diego. He got together with Pearl Jam, they put out 10, Nirvana put out Nevermind, and the grunge movement took off. At that point in time, 1995, could anyone have predicted that Pearl Jam would still be going, would still be rocking, would still be filling Safeco Field, and in fact, has their own XM radio channel? We don't know that. We didn't know that. Unless you're clairvoyant, you can't predict. We're going to hit a couple other hindsight examples in the course of my brief remarks. I was on a jury once, and the first thing we did was we looked at each other and said, what do we do now? That's a Clash lyric, by the way, from London Calling. So we read the instructions. I mean, Ms. Kohler wants you to do one thing, Mr. Snyder wants you to do another, Mr. Puz a third. The judge, though, has given you instructions. So a lot of jurors, I'm not saying this is the only way, but a lot of jurors say, let's read the instructions and see what we find. And very early, before you even get to the instructions, you'll see that something very important was said to you by the judge. That was on the 16th. That's a VRP, means verbatim report of proceedings. I see Kevin giving me a dirty look because he heard me speeding up just a little bit there, because when people read, they always speed up. But the judge said, the only thing that is pertinent here is what the city knew and reviewed before the date of the incident. That's all we're going to look at.
You object to what?
What you just did.
Overruled.
Okay.
The next one I want you to look at is jury instruction number 1 on page 2. Quote, however, it is important for you to remember that the lawyer's remarks, statements, or arguments are not evidence. And that's important because Ms. Kohler stood up in closing and pointed to a picture and said, look, there are 2 traffic lanes north of the bridge in either direction. Well, that's not the evidence, okay? The evidence is there's 3 travel lanes north of the bridge and 3 south of the bridge in each direction, 6 lanes total. So the evidence trumps what counsel would have you believe. Number 1, again on the last page, you must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proven to you and on the law given to you, not on sympathy, prejudice, or personal preference. Every single employee of the city of Seattle feels terrible about this accident, and every single employee would like to turn back the clock, but we can't. And you folks need to have your rational sides guide you through the process going forward. Ordinary travel is something you're going to see in the instructions. The instructions are great, except they don't define a couple of terms. Ordinary is not defined. Reasonably is not defined. So you need to use your common sense to figure out what those terms mean. But ordinary travel does not mean a catastrophic event caused by a criminal act or an axle braking in a big vehicle like in this case. And if they did, I don't know if every roadway would have a median down the middle and barriers on the outside, and then we couldn't get around as a city. So jury instruction number 2 talks about evidence and says you should use your common sense and experience, and that means the type of travel that goes on every day is ordinary travel, and this tragic event was an outlier, not ordinary travel. Just an example, if you're at 85th and 34th and Ballard, there's a windy hill that goes down to Golden Gardens Park, and a couple of the pictures of Ms. Derschmidt were on the beach at Golden Gardens. It's a beautiful place. The road's terrible because people jog on it and ride bikes on it, and there's not really a lot of extra room. So ordinary travel on that road is within the safe speed as marked in the signs. If you drive 100 miles an hour down that curvy road, you're not going to make it, and that's not ordinary travel. We can't engineer roads to account for behavior like that. Mr. Allen, am I pointing at the wrong thing? I thought I had it. That on. Great, thank you. Ordinary care, a reasonably careful person will exercise under the same or similar circumstances. And as Mr. Puz said, we're looking at reasonable transportation agencies in the United States. That's the peer group or the cohort that we're comparing with. We've got over 4,000 miles of roads. The state has over 7,000, and we've had a kind of myopic focus here on a half-mile stretch. Mr. Chang and Mr. Bandy are in the courtroom, and the folks at SDOT are responsible for the entire system. And it's the entire system that we need to be concerned with when we talk about taking a lane away from the York Bridge. There have been assertions by council that the city and state have not done studies of the bridge. That is incorrect. The 2003 route development plan, I'm not going to go there. You guys have the whole thing as an exhibit. It's 334. I would encourage you to skim through it. It's about, as Therese Casper said on the witness stand, speeding up bus traffic. It's about making sure folks can get to and from the city quickly and safely. And as Lance Bullard said, you need 2 things to have traffic work: safety and efficiency. People in gridlock are safe because they're not moving. We needed to be able to make sure folks could get in and out of the city. The city evaluates crash data every single year, and whenever that process was done from 2003 to 2015, the bridge never rose to the level of a high collision location and never triggered further inquiry. We actually do that weekly as well as a city. 2009, the city and state did a joint study of the corridor. The corridor has a high accident rate, but the bridge does not. So when snippets show up on the screen saying high accident rate and you can't read the document in the back, that tells you when you're in the jury room, you might want to read the whole document. This is the diagram that we talked about a little bit during some testimony, and this is the state data, thank you, that went into the 2009 study. And we would respectfully submit that it doesn't take a traffic engineer to ascertain where the problems are in this corridor. And predictably, they're at intersections, and they're intersections that folks know pretty well. 85th, where the Arco station is, 90th, where Pro Ski is, North Gates, where the Jack in the Box is, all the way up to 45th. Halliday down on the bottom was a problem area until the countermeasures were instituted by the city, thank you, as Mr. Chang described in his testimony. And those are the countermeasures right by the Canless restaurant, which enabled those numbers to come down. Here's another slide, and this is 2012, 2014. We talked about this a little bit, but I'm sort of forgetting when that was, so I'm going to just briefly go through it. Average daily traffic on the Aurora Bridge, Ballard Bridge, Fremont Bridge, a stretch on Lake City Way from 120th to 135th, and a stretch on Rainier from Letitia to Seward Park. Ballard Bridge and Fremont Bridge are both drawbridges, and they're both in neighborhoods. And one thing I asked Mr. Pfeiffer about, it was an unfair question. I asked him if he knew where the center of the universe was. If you're not from Seattle, you're going to have trouble with that question, and he didn't know. He didn't know how close the nearest high school is to the Ballard Bridge. It's Ballard High School, 1.3 miles north. And I would submit, because I drive by it every day, that high school kids are a little more dangerous to motorists than elementary school kids. There's a senior center called the Landmark on Old Ballard Avenue. That's 0.6 miles from the Ballard Bridge. There's the BF Day Elementary School is a half a mile north of the Fremont Bridge on Fremont. The biggest the biggest bike route in the city, numerically, by far, is the Fremont Bridge to Dexter, and now the Fremont Bridge to Westlake, which is the new bike path that went in. So when we talk about taking a lane away from the Aurora Bridge, we're putting a lot of folks into neighborhoods where there are people biking, pushing baby strollers, and walking. So these stats, we went through them, and some, I'm not going to belabor it. Collision, fatal and injury per million vehicle miles. 0.41 is Aurora. 0.44 Fremont is a little higher. Ballard's twice as high. The stretch on Lake City Way is 5 times as high, and the stretch on Rainier is 10 times as high. So as responsible city planners, we've got to put our resources there. And the city's doing a lot on Rainier right now because of that problem. But it's interesting that the number is 41, because it gets me back to hindsight. In 1965, the second player drafted in the Major League Baseball draft was a guy named Les Rohr. He was drafted by the Mets, and he had a 2-3 record at the end of his career. He got hurt. There was a guy drafted in the 10th round, Tom Seaver. He wore number 41. He's in the World Series. I'm sorry, he's in the Hall of Fame. He was in the World Series too in '69. So again, hindsight bias. They didn't know who was going to be better between Les Rohr and Tom Seaver. They didn't know who was going to be better between those two and a guy in the 12th round named Nolan Ryan. Hindsight bias. Again, it's perfect. Hindsight is 20/20. We don't have it. We don't get to use it. It's unfortunate, but it's the reality. Been a bunch of discussion about the appropriate selection, or the study period. Mike Sinecki, Don Ho Chang said 3 to 5 years is the relevant time period that folks should use. Thank you. And reasonable engineers focus on high accident locations based on 3 to 5 years of data. We looked at 10 years because this was an extremely serious accident and we wanted to have as much data as we could. And what we determined was 0.6 was the accident rate on the bridge, and that's including the entrance and exits on either side, and 1.86 is a statewide rate. accidents are trending down. The changes at Halliday are what moved that Halliday line, shortened the Halliday line up and caused that 0.41 number to appear. The countermeasures worked, in other words. Zero crossover fatalities and few crossover injury accidents. Again, zero crossover fatalities in 10 years. And this is tragic, and it doesn't make the folks who are hurt or lost their loved ones feel better when we say it was an outlier. But what we're dealing with is probabilities and protecting as many folks as we can with the countermeasures that are available, with the resources that are available. Traffic engineers look at traffic volumes, speeds, and reported collisions. Those are the three cornerstones of what they do. After the 2008-2009 study, the city decided not to pursue the median barrier idea. And the reason is what that data directed us to was doing other things on the corridor. And the 2009 study that Mr. Bandy talked about showed that with education and enforcement, we were able to correct the behavior that was worrying SDOT, and that was folks getting hit in crosswalks by right-turning vehicles, and that was speeding on the entire corridor. So, excuse me, if you take the corridor over the weekend, you'll see there are the radar signs that blink and tell you if you're going too fast. The 2009 task force, those were the results. Total crashes down 21% and total injuries down 13%. I'm sorry, and that's Exhibit 40201. And those are the Bates numbers. So 40201, page 0146011, and 011.23.
Bates.
0146011.23. Thank you. I missed my next hindsight bias point. Ms. Kohler went with Cher yesterday. I couldn't go there. So I went with Jackson Brown. I know that's old. A song called Fountain of Sorrow. Now for you and me, it may not be that hard to reach our dreams, but that magic feeling never seems to last. And all the future's there for anyone to change, still you know it seems it would be easier sometimes to change the past. That's Fountain of Sorrow. It would be easier sometimes to change the past. But again, we can't, and we have to look forward. Ed Stevens talked about the Caltrans warrant. It may be an incredibly valid statistic for some reason, but the number of accidents on a roadway in a mile without a reference to the volume doesn't seem like that helpful a number to me. Caltrans warrant has not been adopted in the state of Washington, not been adopted by very many states as near as we could tell from Mike Sinicki's research. It's not the same as a high crash rate. And what it says is, if you get to a certain number, you have to do a study. And the 2008-2009 study was a study. And the city does studies of high collision locations every year. So the question is not whether or not the Aurora Bridge could have been safer, but was it reasonably safe for ordinary travel on the day of the accident? That's jury instruction 19. And did the governments exercise ordinary care to make sure that was the case? And that's defined in jury instruction number 15. And did the government's breach of the duty cause the accident and cause the injuries of particular plaintiffs? That's instruction 14. And here I've got about 20 minutes of slides on which duck entity is most responsible, but I think I'm going to skip that and we're just going to move on. Problems with fixed barriers. When I asked the traffic engineers, what's the biggest problem with the fixed barrier? I'm sorry, with a fixed median barrier in the middle of the roadway? They said, in this location, it's going down from 3 lanes to 2. Because when people have to go from 3 lanes to 2, they speed up, they don't behave nicely, they suddenly ignore all Seattle driving protocols, there's no more taking turns, it's everybody's in it for themselves. And I don't know if you folks have noticed, the Seattle squeeze is causing more aggressive driving behavior, okay? Everyone is, they're listening to the traffic report and they're starting to drive more aggressively. So the big problem is you lose a lane. And going from 3 lanes to 2, that's problem number 1. Losing the lane causes problem number 2, which is it puts a bunch of cars down on the Fremont and Ballard bridges, both drawbridges. And everyone in this jury box and everyone in this courtroom knows the first thing you do when the drawbridge goes back down is you try to speed up and make time, right? So I don't know what percentage of the ADT is going to go down on the Fremont and Ballard bridges, but it's going to create congestion and it's going to create danger to the vulnerable users, the folks on the bikes and walking and jogging and with strollers. Excuse me. They don't have seat belts. They don't have airbags. They don't have crumple zones, and they don't have a big metal vehicle to protect them. So we don't want more cars where there are lots of pedestrians and bike riders. People hit the median. People bounce off the median and hit people going in their direction. And people in trucks hit a median hard enough, it gets displaced into the other side of the road, and there can be a head-on collision with a median, which is a bad thing. So it's clear that a center fixed median barrier would have prevented this particular accident from occurring. But it is also clear, based on the evidence, that it would have increased the overall number of accidents in the system. I used to work with a guy, and I would make what I thought was a really good suggestion, and he would say, okay, Dad, I'll give that the attention it deserves. I don't know that the median zipper is worth a lot more attention than we've already had. It doesn't fit at either end of, I thought it was a Zamboni-sized gizmo, like they clean the ice off with between periods, but it's even bigger. And Mr. Pfeiffer's examples, they're 12 feet wide. Mr. Puz had some even wider one. And that's the area where the zipper barrier moving gizmo would have to go. So there's the north end of the Ballard Bridge. And we talked a little bit earlier about how many lanes of traffic there are. 3. There's 3 over there too. That says bus only, or only bus. So those of the right lane, that guy's not supposed to be in the bus lane, but maybe he or she's going to turn right. So that's the north end. Same problem on the south end. There's no place to put the big machine that moves the zipper and the zipper barrier, and the only way that it could be moved is what's called a rolling slowdown, and that's what the State Patrol has to do on I-5 when someone drops an appliance off the back of their truck. They have to slow everybody down so the workers can get it out of the way. That's an emergency emergency method of removing a dangerous object from the road. It's not something you design for. So the two groups of folks here, the exchange students who were tragically hurt on the bus, hurt and killed on the bus, and then there's the folks on the duck. The evidence shows that the duck had it crashed into a median barrier at 36 miles an hour and 9 miles an hour laterally with open windows. Passengers would have been injured. They would have been thrown around, and it's unclear who would have been thrown around more, less, the same. The plaintiffs did not meet their burden to show that the allegedly missing median barrier would have minimized the injuries to the duck passengers. Mr. Puz talked about damages. We've got a lot of folks to talk about. We've got 4 defense attorneys. If we all talked about 40 people, we'd be here till the Ides of March, and we don't want that. So we tried to figure out a way to deal with folks in an organized fashion. Mr. Puz, to be perfectly honest, forgot to put his last slide up. It's up now. We endorse the comments that Mr. Snyder, Ms. Buchanan, and Mr. Puz have made. There's a couple of different ways to look at damages in this case. We're totally fine with the numbers suggested by our colleagues. But there's a couple of things I want to focus on. You will see the phrase reasonably and fairly compensate the plaintiffs in slides 31 through 47. That's a very important phrase, excuse me, because that's your job. It's not to pick an arbitrary number, it's to reasonably and fairly try to make people whole for what they've gone through. Let me talk for a minute about the couple of things. Mazda Hutapea should get $1.75 million. Excuse me. We think that's a fair and reasonable amount. And what I'd like to point out is that the plaintiff's number is a lot higher because Tony Chapa assumes she will be in the 25th percentile of employment when she starts and for the rest of her career. And I think the evidence shows otherwise. She's getting a 3.3 at the UW. Mr. Snyder was going to talk about his GPA. I'm not going to talk about mine, but it was lower than a 3.3. She's going to succeed. And it is, the evidence is what you saw on the witness stand, that energetic, personable young woman who is going to succeed as a chemical engineer. How are we doing on time, Your Honor? Good. So there's one other elephant in the room, and that's the whole PTSD thing. And there was the blaming the victim book yesterday, and we heard a lot about that, and that's not what we're trying to do. I get it. Some people aren't going to go to a psychiatrist or a psychologist. My wife is from Oshkosh, Wisconsin. People from Wisconsin and many other countries are not going to go. Okay, Frazier was based in Seattle. Laverne and Shirley was based in Milwaukee. Okay, we don't have a problem. The city of Seattle doesn't have a problem with people treating or not treating, or treating with a psychologist or talking to their skateboarding buddies like Felix Dershman. You know, it's totally their choice. What we have a problem with is Dr. Olson describing 96 visits for Simon Lee, and Tony Chapa saying, oh, those 96 visits should take place at Harborview at $300 to $400 a pop. So we're up to $38,000. Now Simon Lee, not to be confused with Kyle Bolton, they both drove by, saw this horrific crash, and ran back. Bolton decided he couldn't help, heard sirens, and left. Simon Lee stayed a little longer and now claims emotional distress because he felt helpless. In the 3 years since the crash, I asked him, have you taken CPR? No. Have you taken first aid? No. He has done nothing to avoid going through that again. Now, I don't know what it's like for folks in Korea and whether or not they're likely to seek treatment, but you can't award reasonable and fair damages for psychological treatment. That's not going to occur. So I was going to end with Mr. Lee, but I guess I started with him. We've got him down as, well, we'll get to him in a sec. Ms. Zielinski. Ms. Zielinski's married to the older gentleman who's a lawyer. She's had some real significant injuries, no doubt. Medical care, that's the past medicals, $114,000 give or take, and she lives in the Netherlands, so she doesn't have to pay medical care going forward. But she still had a significant injury. We've got her down at 1.85. Rhonda Cooley. Council has spent a lot of time talking about Rhonda Cooley, but that's not evidence. What was the evidence? The evidence was she missed 85 plus days of work on in a couple of years. That was 85 plus per year for 2 years. She told her doctor she was at the end of her rope before the accident, and her family was urging her to quit Federal Express. And then she told me Federal Express doesn't have light duty. That's the evidence. 69,000 undisputed specials. We've got her down at 750. Ms. Gerke, her wife, This is a tragic situation. They were at the Space Needle, and they had Packer gear on, and somebody saw them and started talking about the Packers because the Packers had just played the Seahawks, and they missed duck number 8 and ended up on duck number 6. So it's a tragic combination of circumstances that brought Ms. Cooley and Ms. Gerke here. Damages are a little lower. She has been able to return to work as a driver's ed instructor, not as a gym teacher, so she is able to earn some money, and we've got her down at $500,000. And these are numbers that we think are fair and reasonable, but you folks are the ultimate decision makers, obviously. Kathy Sheldon had a problem psychologically, sought treatment, and got better. Past medical costs, which Ms. Kohler said were nominal yesterday, so under 50,000 basically. Yeah, they're under 50,000, more like 6 to 11. But she was injured, and she got treatment, and she got better. So the non-economic damages, we suggest 75,000. And what Mr. Snyder talked about earlier was kind of goalposts for the 22 who just have the general damages, the non-economic damages now, with 75 or 100 as the high end of the goalpost, and 20 or 25 at the low. Mr. Lee, I've talked about, I think 25,000 fairly compensates him. And just in closing on those claims, a lot of the evidence that you have is from Dr. Olson and Tony Chapa, who combined billed over $1 million to testify in this case. So that is worthy of your consideration. Plaintiff has the burden of proof. They start at 0, so everything has to be proven by more than 50%. I think Mr. Puzz already covered these. We would respectfully suggest that you check no for the city negligence questions. If you choose to go yes, 3% total for both government entities. Again, that's just a number that I think is supported by the evidence. The mitigation of damages, whether or not folks should get money for treatment that they're not getting, that's jury instruction number 48. That's the one Ms. Kohler doesn't like, and it's just as important as every other one. She gets to go last. She's got the burden of proof, so she goes last, and she's going to do a couple things, probably show the video again, and then also say that the defense are conspiring. And if we're conspiring, this is one of the most unorganized, disorganized combinations or conspiracies I've ever seen. I don't think Mr. Puzz and Mr. Snyder have each other on their Christmas card lists going forward. But so we end where we start. We started talking to this juror number down here, who was 117 at the time, I think, about the memorable day when Russell Wilson threw the interception. And at the time that Russell Wilson threw the interception against the Patriots, Darrell Bevel, the offensive coordinator of the Seahawks, a former Wisconsin Badger, by the way, thought it was a really good idea. He lost his job as a result. He just got a job with Detroit as the offensive coordinator. The call goes through Pete Carroll's headset. So Pete thought it was a good idea too. He didn't say, "No, we can't pass. Russell Wilson gets the play. He can change the play if he wants to. He's the man." He thought it was okay too. Why? Didn't they know? No, of course they didn't know. Hindsight bias is always, hindsight is always perfect. Hindsight is always perfect. And I don't have Maya Angelou. I've got Kurt Vonnegut. Of all the words of mice and men, the saddest are what might have been. Thank you for your attention.
Thank you, Mr. Cedar. All right, as Mr. Cedar said, and as I've told you repeatedly, plaintiffs have the burden of proof, so they get the final word here. I'm going to ask you just a moment when she's had a chance to set up, that you give your attention again to Ms. Kohler and rebuttal closing argument for the plaintiffs.
Ladies and gentlemen of the jury, it is hard, I have to admit, to listen to other people's versions and not want to come up to you and bullet point every single thing that we disagree with, some things very vehemently. But that's what I'm going to do. I am not going to respond by bullet point. These are the words of one of the original freedom fighters from the 1960s. If not us, then who? If not us, then who? If not now, then And what we just heard was a lot of, wasn't us, wasn't us, wasn't us, it was nobody's fault what happened. If you write no in any of the instructions, then it won't be their fault. If not us, then who? If not now, then when? 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 When were you going to get that Axel housing fixed? It was not us. Well, then who? And so we get down to the end of the case, and guess what? It's you. You are going to decide for everybody in this case, for everybody that's been watching this case, for your communities, for our Constitution, for our judicial process. You are going to make the decisions. And it's a very important decision. Your decision will impact over 40 people and their families. It will impact the state and the city, and Ride the Ducks International and Ride the Ducks Seattle. So after listening to us for 4 months, and taking as diligent notes as you have, and asking as intelligent questions as you have, and as keeping your eyes open even when we were so mired in the details. Fight for what you know is right. This was not a small little thing that happened. Let your verdict ring with certainty. Let the people that this crash hurt and the families of those that were killed know how bad the damage was done to them. Fight for them.
Objection.
Sustained.
It wasn't them, it's you. It wasn't them, it's now. Thank you for very much for giving us all of your attention. Thank you.
Thank you, Ms. Kohler. All right, ladies and gentlemen, earlier today, Andrew went and got this old wooden box I mentioned to you a long time ago when we were in jury selection. In the old days, we used to call people up from the rows to get questions from this box. These days, we use it to select our alternate in our cases. We put in the numbers of the people who are here, that were usually here, and all the lawyers took a look to make sure we got the numbers right. And so now in open court, Andy's going to roll this drum and pull out 2 numbers in a row. The numbers that come out in the order that come out will be the first alternate and the second alternate on this case. If your number is red, do not get up and leave. I'm going to have some additional instructions for you. Go ahead, Andrew.
In order, 4
Okay.
and 5.
All right. So, Mr. Chepkin and Mr. Frederick, what's going to happen now is that you're going to head back downstairs with Andrew to pick up your belongings downstairs and to give him your notebooks and notepads as you go so he can keep them safe for you. When you get downstairs and you get your belongings, make sure that you give Mr. Ulmer a really good idea about how we can reach you quickly and a sense of what your schedule looks like over the next week or so. Keep our contact information. You're welcome to call in or email in and find out what the status of deliberations is. Obviously, if the jury reaches a verdict, we're going to be excusing you from jury duty and sending you a certificate to say how much we appreciate you. And I will tell you right now, just in case we send one of those certificates, we totally appreciate you and all the work you put in. But I need you to be really, really careful before there is a verdict not to research or talk to anybody about this case. You're still on jury duty, even as first and second alternate, because obviously if one of the other jurors becomes sick or can't continue for some reason, we have to bring you in, and you need to come in completely untainted. That is to say, without having had any improper discussions or done any research in the case. So keep acting just like you have during the trial, okay? And feel free to stay in touch with us so you can keep track of what is up with us. And if there's a verdict, we will tell you about that, and we will tell you about anything else that's happening with the jury at that point. All right? Yes, Mr. Cedar?
We have a very short sidebar before anyone is dismissed.
Sure. Super short. Hang on one sec, folks. Okay, so thanks everybody. We just needed to chat really briefly. So Mr. Shepkin, Mr. Frederick, head on downstairs with Mr. Ulmer. Bring your notebooks and notepads with you so you can give them to him. We look forward to seeing you again if we do. If not, thank you again so much. Please rise for our two alternates. Be seated, everybody. All right. So for you folks, you are now the jury in this case. And I have a little bit more in the way of instructions for you, which is to say I have some directions for you that you are required to follow. And then I have some suggestions that you're not required to follow. Let's see if I can get this screen moved so I can see all of you. What do you folks want to do over that work too? I just want to check to see all of our jurors, including the ones who are blocked by the screen. Thanks, everybody. All right, so here's the additional instructions that I need to give all of you. The first instruction has to do with your ability to talk about this case, and the second has to do with your scheduling. You can now talk about this case, but only if two conditions are met. You have to be in my jury room, meaning one downstairs on the 8th floor, with the door closed and locked behind you. That's the first condition. The second condition to talk about this case is all of you have to be there. If one of you steps out to pollute your lungs with cigarette smoke, which I hope none of you ever do, or to make a phone call or to use the facilities or for any reason, then the rest of you need to talk about some other topic, but none about this case. So obviously this requirement that you can only speak about this case with each other when you're all there means that you cannot speak to anybody else. You can't talk to Mr. Ulmer or your family or your friends or any other human being about this case. You can only speak to the other 11 of you when all of you are in the room and attending. The other thing that this implies is you can't have any virtual meetings if you follow me. You can't set up a Facebook page and chat there. You can't have, tweeting at each other. You can't go out to dinner together to talk about the case. You have to stay in the jury room downstairs to talk about the case because that's the only way we can preserve the privacy of your deliberations. All right, so under those two conditions, you can now speak about the case. Make sure they're both met before you talk to each other and only each other about your deliberations. The second order or additional instructions I have to give with you has to do with our scheduling. Obviously, a good deal of the court's daily schedule is based on court staff. So I'm going to liberate you from some of the things that we do for court staff. But I need to tell you that even though I'm going to let you set your own schedule, there's still some limits on it that you need to be attentive to. The first limitation is you can't deliberate earlier than 8:30 in the morning, and you can't deliberate later than 4:30 in the afternoon, because my staff's hours are 8:30 to 4:30, and I can't make them come in early or stay late for you. Second restriction on you is you're welcome to cut your lunch hour down to an hour, and you're welcome to set it any time between 12 and 1:30, but it has to fall between 12 and 1:30, and it has to be at least an hour so that Mr. Ulmer gets to eat lunch too. You can get rid of the mid-morning break if you want to, and the mid-afternoon break, that's completely up to you. Your deliberating days are obviously Monday through Friday because the court's not open on weekends, and you also won't be able to deliberate on any legal holiday that might come along. So those are the boundaries of your schedule. You're going to want to sit down with each other and figure out your deliberation schedule fairly early, and then just let us know. Once we have a sense of when you're going to be here and deliberating, let me tell you a couple of things about that. One is that realistically, we have a lot of parties in this case, and if you come up with a verdict toward the end of the day, especially after 4 o'clock, it's going to be virtually impossible to round everybody up to take your verdict until the next business day. So just be alert to that. I'm not telling you anything other than this is how the court day works. A second thing I want you to be alert to is that Mr. Ulmer is going to be really attentive to you. When you're downstairs in my jury room, you have this extremely irritating buzzer that you can press. It makes a horrible sound in chambers, and he runs right in whenever he hears you call to him by pressing your buzzer. He also keeps you informed about what his schedule is, so if he's leaving the courtroom to do something like go pick up mail, you'll know that he won't be around briefly. Be attentive to communicating with him before you ever walk in or out of the jury room, because you do not want to be walking out unexpectedly. Even down on the 8th floor, the chances are decent that you'll run into something connected to this case that might taint your ability to continue as a juror. Follow me, set your schedule, let Mr. Ulmer know, stay in touch with him, and if you decide, for example, to change up your schedule by taking a break you hadn't told him about, make sure you let him know before you actually take the break, okay, so that he can release you from the jury room. He'll never leave you neglected, I promise you that. All right, that's it on additional instructions, okay? Now I want to turn to suggestions. And this is the part where you do not have to follow my directions if you don't want to, because these suggestions are, I hope, something that you might find helpful, but they're not binding on you. I'd suggest that before you pick your presiding juror, that you take a few minutes to reintroduce yourselves to everybody, and maybe share your thoughts about how a deliberation should be organized and conducted before that presiding juror is actually selected. I'd suggest that you give some careful thought to who you pick as the presiding juror. I'd suggest you look for somebody who's a good listener and a good observer, somebody who will organize the evidence and your discussions, and somebody who will ensure that every juror has a fair chance to be heard. You might want to pick that person by written ballot. That's up to you. As you start deliberating, I suggest you think about the following. It's vital that you respect each other's opinions and the different viewpoints that each of you brings to this process. It's also vital that you're not afraid to speak up and express your own individual views. I suggest you be patient and generous in letting everybody get a chance to speak. Your differences of opinion as a jury are healthy. You'll find they bring the issues into focus. They'll bring out ideas that you individually might not have considered. I'd suggest you listen carefully to each other. It is fine to change your mind, but obviously don't let yourself be bullied into doing that, and needless to say, don't bully anybody else. I'd strongly suggest that you not rush into a verdict to save time. I don't have to tell you that the parties in this case deserve your thoughtful consideration, and frankly, our jury system depends on that. Each of you has to decide this case for yourself. I suggest you do that only after you finished reviewing the law, carefully considered the evidence that was presented to you throughout this trial, fully and fairly discussed the issues in the case with the other jurors, and listened to what they have to say. I suggest you finish talking about the law and the evidence to all of your satisfaction before you take any vote. In terms of organizing your discussions, you can move forward in any way you think is productive and fair. Many juries start by going through the court's instructions on the law together, because those are intended to identify all of the issues and propositions and claims that you are supposed to consider in this case. Other juries start by going around the table and having each of you in turn speak up and say what issues or concerns you would like to have discussed, because that encourages all of you to freely express yourselves before anybody takes that formal position. Many jurors find it helpful to list issues on which you may differ, and if you want to do that, we've got the equipment downstairs. There's a whiteboard, there's a flip chart, we can get you markers and things like that if you'd like to list issues on which you may differ. There isn't any set way for a jury to vote. Juries can choose to vote by a show of hands, by voice vote, or by written ballot. Again, I suggest you pick a method that you think will encourage each of you to freely express your own thoughts and conclusions. And one more time, these last remarks are just suggestions. Of course, I hope they're helpful, but nothing I've said or done in this case should suggest to you what your verdict should be. That's for you to decide. All right, what we're going to do now, because it's almost the end of the day, is send you downstairs with your notebooks and notepads this time to talk to each other to begin with about your schedule. We will be looking through and organizing the evidence to make sure that you get what you're supposed to get to work through your deliberations in this case. If you have a sense of what your schedule will be starting next week, of course, tell Mr. Ulmer and let him know too when you intend to break today. Thanks, everybody. Please rise for our jury.